30082OM. This is Van Buren Township versus Lindsay Dineski.
Yes, ma'am, that's me.
On behalf of the people.
I'm sorry, ma'am. State your name for me again.
Lindsay Dineski.
Thank you. Today is the day and time set for the arraignment and pretrial on this matter. Ms. Dineski, the way the court staff have you labeled indicate that you're waiving your right to have the assistance of the court-appointed attorney. Is that correct, ma'am?
Yeah, I'm studying to be a lawyer. I would not need that.
Before we even hear the first word in this courtroom, you need to understand what kind of case this is, because this isn't just a routine arraignment. What you're about to watch is a masterclass in how not to conduct yourself in court. We have a defendant who believes that simply declaring something illegal, erroneous, or under color of law somehow overrides the authority of the judge, the prosecutor, and the entire legal system. She claims to be studying law, threatens lawsuits before the judge even finishes speaking, and insists she does not consent to being prosecuted. As if consent is optional in criminal court, this case quickly turns into a collision between reality and delusion, where courtroom procedure meets conspiracy thinking. You'll see repeated attempts to hijack the hearing, derail the process, and intimidate the court with buzzwords pulled straight from sovereign citizen playbooks. But what makes this especially compelling is how calm, methodical, and patient the judge remains while the defendant spirals deeper into accusations, threats, and self-inflicted legal damage. So pay close attention, because every interruption, every claim of victimhood, and every legal misunderstanding you're about to hear actually makes her position worse. And by the end of this hearing, the court makes something very clear: refusing to consent does not exempt you from consequences.
That being the case, have you had the opportunity to speak to Ms. Manarino this morning?
Yes. I think all charges should be dismissed because this is retaliatory action for asking for a child to be protected.
Ms. Manarino, how are we proceeding this morning?
Your Honor, based on my discussion with Ms. Dineski this morning, she is requesting to have the matter set for a jury trial.
I'm actually requesting for dismissal, and she insisted that I either take a plea or go to trial, but I think that it should be dismissed because it's retaliatory and it's in violation of several of my rights, Michigan and federal rights, under the Constitution of both.
This is the first red flag, and it's a big one. Claiming to be studying to be a lawyer while simultaneously rejecting court-appointed counsel is not a power move, it's a liability. The judge immediately calls out the distinction between actual legal education and merely applying to a junior college, and that distinction matters. Courts are required to ensure defendants knowingly and intelligently waive their right to counsel. Simply saying, "I don't need a lawyer," doesn't magically make you qualified to represent yourself. What's happening here is a classic overconfidence trap. The defendant believes familiarity with legal terms equals legal competence. But the law is procedural, technical, and unforgiving. Judges don't grade on effort, they rule on compliance. And self-represented defendants are held to the same standards as licensed attorneys. That means every misunderstanding, every incorrect filing, and every misstatement of law will count against her. This moment sets the tone for everything that follows. Instead of approaching the court with humility or strategy, she leads with ego. And in court, ego is expensive.
Plea not guilty.
Thank you. That's the recommendation from Van Buren Township, ma'am, is that they do not oppose personal bond, and that was going to be the court's intent. Set your bond at $5,000 personal. You do not need to post any money. But what you must do is continue to appear as directed by the court until this case is resolved in its entirety. The arraignment having been completed, the next step is pretrial. You've both already indicated that you've had some conversation regarding pretrial. Ms. Dineski, I understand that you have a defense that you want to present. Today is not the day and time to present that defense. If you want the matter scheduled for a jury, the court is happy to schedule the matter for a jury trial. In our interim, there's also a request that you have no contact with Charles Nerswick, Nerswick. Do you have any reason to be in contact and communication with that person?
Yeah, we have children together, and he kidnapped one of our children, which is what I was actually calling the police about. And he has our child in danger, and they refuse to listen. And now she's gone. She's missing. So I will be countersuing Romulus, I guess it would be Van Buren. And if the court proceeds with this, I will be also bringing the malicious prosecution against this court as well.
This exchange is quietly devastating for the defense, even if she doesn't realize it. An arraignment is one of the most basic procedural steps in criminal court. It's where charges are read, rights are advised, bond is set, and a plea is entered. It is not where evidence is argued or innocence is proven. When the judge has to explain this distinction, it highlights a fundamental lack of understanding. Notice how the judge doesn't argue or belittle, she redirects. She gives the defendant an opportunity to correct herself. That's judicial restraint. But it also puts the defendant on notice. This court will follow procedure whether she likes it or not. When she finally says, not guilty, that's the only legally relevant answer at this stage. Everything else she's arguing is premature and irrelevant. This moment matters because it shows how the defendant keeps trying to force the court into her narrative, rather than operating within the court's rules. And courts don't bend, they document.
Because these are erroneous charges and they're retaliatory, which is a violation of my freedom of speech. It's a violation of my right to due process. So if this does not get dropped today and it moves forward, I will be filing under color of law lawsuits against Van Buren and this court in federal court for violation of rights under federal question jurisdiction. So I just don't think it would be a good use of the court's time or resources to continue this malicious prosecution. And I could quote case law, I could quote laws that Van Buren police broke. They completely ignored my evidence. There was obstruction of justice. They said there was sexual discrimination against me because I was a woman. I have all the calls recorded. I mean, it would really be a waste of the court's time.
Here's where reality briefly steps in. The court grants a personal bond, meaning she doesn't have to post money, which is actually a favorable outcome. Many defendants would be relieved. But instead of recognizing that leniency, she escalates. This is a recurring theme. The court gives her something reasonable, and she responds with hostility. The judge is crystal clear. Today is not for presenting defenses, accusations, or conspiracy theories. If she wants a jury trial, the court will schedule one. That's due process in action. But instead of accepting that path, she insists on arguing facts, motives, and alleged crimes by others, none of which can be resolved at this stage. This is where defendants often hurt themselves the most. Judges remember cooperation. They also remember defiance. And while bond conditions are legal safeguards, they're also a test. Can you follow instructions? Everything from here forward builds on how she answers that question.
The one who broke the law was Van Buren Township, not myself.
Ms. Dineski, I said it before, and I'm not sure if you heard me or understood that today is the arraignment. Today is the first.
Yes, but I could ask for it to be dropped at the arraignment. I'm allowed to ask for the charges to be dropped because they're erroneous. So my liberty should not be affected by erroneous charges. I should not have to keep showing up at court and have a bond. That's a violation of my liberty. This is malicious prosecution. Chuck has friends at the Van Buren Township. His father used to be the fire, one of the high, he was like the assistant fire chief. So there's bias there. They refused to listen to me. He tried to kill me, and then he took our child. And when I talked to the police about it and said that under Michigan law, he should not be with a child because he's suicidal, homicidal, and he's isolating with a child, everybody ignored me. And then they pressed charges against me for asking them to help me.
And here we go, the lawsuit threats. This is where the hearing fully derails. Threatening to sue the court, prosecutors, and police during an active criminal case does not intimidate anyone. Judges hear this constantly. In fact, it often signals exactly what the court is dealing with, someone who believes legal jargon is a weapon rather than a framework. Notice the language, under color of law, federal question jurisdiction, malicious prosecution. These are real legal concepts, but they are being used incorrectly and out of context. Courts don't dismiss cases because a defendant declares them unconstitutional. They dismiss cases based on motions, evidence, and law, filed properly, at the proper time. Ironically, every one of these statements is now part of the record. They don't help her civil claims later, they hurt her credibility now. When people say, the court won't listen to me, moments like this are usually why.
Ms. Dineski, just so you're clear, this matter is being recorded and we're streaming live on YouTube. I only say that so that you may be mindful of the things that you say. Ms. Manarino, you were starting to say something.
Yes, Your Honor, as it relates to bond, I understand that Ms. Dineski has an issue with the no contact. When I spoke with the complaining witness in this matter, he did indicate that he did not have an issue with Ms. Dineski having contact with him as it relates to the two biological children they have in common. As it relates to any other matter, he would not like to have contact from her during the pendency of this matter.
So, Ms. Dineski, I will ask you the question a different way. Do you have any reason to be in contact with Mr. Nurswick other than to make arrangements regarding the children?
Haley is my child. She's not my biological child, but legally she is my child. I've cared for her for 5 years. I'm the only mother she knows. So yes, I should be able to have contact with him regarding Haley because he kidnapped her legally under Michigan law. I am a parent and I have as much right to her as he does as a biological parent.
This is an important and often overlooked moment. The judge explicitly informs her that this hearing is being recorded and streamed live. That's not a threat, it's a warning. Judges do this to protect defendants from themselves. Everything said from this point forward is preserved. Instead of adjusting her behavior, she doubles down. She continues making accusations, alleging criminal conduct by police, perjury, kidnapping, and conspiracies, all without evidence being presented. Courts are not therapy sessions. Allegations without proof do not move cases forward. They stall them, and sometimes escalate consequences. At this point, the judge is managing risk. The more the defendant speaks, the more potential violations arise. And yet, the court still offers procedural fairness. That patience won't last forever, and you can hear it thinning.
The court, when gave him custody, used me as a deciding factor as to why he got custody of that child. So that actually, just that particular statement shows that this is about him abusing myself and Haley and using the court as a shield to keep a mother away from a child. And the fact that he took her away from me, she's not been away from me more than 3 days since the day I met her. And he hasn't let me talk to her in 2 months. And that's extremely mentally damaging to her because she already has issues. Because when I met her, a bio mother had abused her and neglected her. And I had to work with her for 5 years to even get her to be able to be at the same level as somebody her age because she was so behind due to the abuse and neglect from Charles and the bio mother.
This is the first time the defendant actually asks for something procedurally correct, discovery. And notice what happens, the court grants it. That's important. Despite all the disruption, the legal system still functions. The judge notes the request and schedules the next hearing. This directly contradicts the defendant's claim that the court is refusing to follow the law, but immediately after receiving what she asked for, she undercuts herself again by declaring she will not follow a no-contact order. That's not civil disobedience, that's contempt territory. Court orders are not optional opinions. Disagreeing with them doesn't nullify them. Violating them results in arrest. This is the moment where consequences become very real. The judge explains them clearly. Jail is no longer hypothetical.
And now he tried to kill me. He said he was suicidal and then kidnapped our child. And then used Van Buren police to maliciously prosecute me when I tried to assert my rights to that child and my right to protect that child. So again, the only people who have committed any crimes here is the Van Buren police and Charles Nurswick.
Ma'am, the court will impose a condition of bond that you have no contact with the complainant in this case, except as is necessary to make arrangements regarding the biological children. I heard your request for a jury trial, but I've also listened to the comments that you just made, and I want to disclose to you that I am married to an elected official in Van Buren Township. He is not involved in the day-to-day operations of the Public Safety Department, the issuing agency in this matter. But based on the comments that you've made, ma'am, I'm not sure if you wish to have this case remain here with me, or if this matter should be adjourned to Judge Green's docket. She next takes the Van Buren Township docket with a date available on April 20th for a pretrial conference. How do you wish to proceed?
Is that where I can ask for it to be dismissed?
You can make that request at every hearing, ma'am.
Well, that's what I was doing today, but you said that was not appropriate.
Because there's been nothing received from the court other than the charges. So the arraignment is just the reading of the charges, the setting of bond, and then the scheduling of the next matter unless the parties have reached an agreement. So there's
that's what I'm asking for the agreement due to the fact I was not given any evidence. I have proof that Chuck took this and tried to use it in a court to try to kidnap the biological children from me. And the court didn't grant it because it was, again, erroneous and the court saw through that. But he conspired with the Van Buren police to have these charges brought against me, and he perjured himself. The Van Buren police perjured themselves when they asked for this warrant, I was not given the information. I was not given the information as to what I did wrong. They kept that information from me. I was not properly served on this matter either. I mean, everything is completely improper in this entire case. Plus, it's erroneous and they're false charges.
Ma'am, are you requesting information from Ms. Manarino at this time?
I mean, I called and asked for information back when I first got the letter, and nobody would give me anything. I've called and I left her messages, I think, at least twice. So, yeah, I would like to have every single thing that they use to get an erroneous warrant on me.
Ma'am, based on that, the court will make an indication in the file that you've requested discovery. Now that you've
Thank you.
requested discovery, we'll put the matter over to Judge Green's docket. That will be
April 20th at 9:20.
April 20th at 9:20 in courtroom number 3, back on Zoom with Judge Green. Ma'am,
And I would like to know why I would not be allowed to talk to Charles about my daughter, Haley. I will not abide by that, by the way. I will not. That's illegal. And I do not have to abide by an illegal order.